Before I begin, can I just confirm that everybody can hear me clearly?
Yes, we can hear you.
Yes, we can.
Lovely. Can I also just confirm with Mr. Johansson that the live streaming of this event has commenced?
Yes, I can confirm that the live stream has commenced and the recording has started.
Lovely, thank you ever so much. The time is now just after 10 o'clock and I'd like to welcome you all to this preliminary meeting which precedes the examination of the Hornsea project for offshore wind farm. This is an application for development consent to construct, operate and maintain Hornsea 4, which would comprise of up to 180 wind turbine generators, together with associated offshore and onshore infrastructure and all associated development. Hornsea 4 would be located approximately 69 kilometres due east of Flamborough Head and will cover an area of approximately 486 square kilometres. The wind farm would be connected to the national grid via an offshore export cable, which would make landfall east of Fraysthorpe, where it would connect with onshore export cables, which would run in a southwesterly direction for approximately 40 kilometres to the proposed onshore substation, which will be constructed adjacent to the existing national grid substation at Creekbeck near Cottingham. Full details of the proposed development can be found in Chapter 4 of the Environmental Statement, which can be found on the Planning Inspectorate webpage in the Examination Library at reference APP-010, or in Schedule 1 of the Draft Development Consent Order, which can be found also in the Exam Library at reference APP-203. The proposed development is a Nationally Significant Infrastructure Project, or NSIP, for the purposes of the Planning Act 2008, as it would have a capacity of greater than 100 megawatts. It is for this reason that the application falls to be determined by the Secretary of State for Business, Energy and Industrial Strategy. I'm now going to introduce myself and the rest of the panel. My name is Jo Dowling. I'm a planning inspector and a chartered town planner. I've been appointed by the Secretary of State to be the lead member of the panel to examine this application. I'm now going to ask my fellow panel members to introduce themselves.
Good morning, I'm Stephen Bradley. I have a background in architecture, capital project development and heritage management.
Good morning, I'm Gavin Jones. I'm a planning inspector and I'm a chartered town planner.
Good morning, my name's Rod MacArthur. I'm a chartered architect with a background in large-scale development and sustainable design practices.
Hello, I am Andrew Marn and I have a background in ecology and environmental impact assessment, and I'm a chartered environmentalist and a chartered landscape architect.
I can confirm that all members of the EXA have made a formal declaration of interest and that there are no known conflicts of interest with regard to us examining this application. Together, we constitute the Examining Authority, or EXA, for this application. You will have already spoken to and heard from KJ Johansson, who is the case manager for this project. He has replaced the previous case manager, Liam Fedden, who you may have had some correspondence from previously. Mr. Johansson is being supported today by Caroline Hopewell and Dre Riaz. Together, they make the case team for this project, and if you have any questions or queries, they should be your first point of contact. Their contact details can be found at the top of any letter you have received from us or on the project page of the National Infrastructure website. Before I consider the items on the agenda for this meeting, I now need to deal with some additional housekeeping matters to those raised by Mr. Johansson in the arrangements conference. As far as I'm aware, no requests have been made for any special measures or arrangements to enable participation in this preliminary meeting. Can I just check that that is the case? Good. As I've already mentioned, this event is being live streamed and it is also being recorded. As was explained in my letter of the 24th of January 2022, because the digital recordings that we make are retained and published, they form a public record that can contain your personal information and to which the General Data Protection Regulation, or GDPR, applies. The Planning Inspectorate practice is to retain and publish recordings for a period of 5 years from the Secretary of State's decision on the Development Consent Order. Consequently, if you participate in today's preliminary meeting, it is important that you understand that you will be recorded and that you therefore consent to the retention and publication of the digital recording. The EXA will only ask you for information to be placed on the public record that is important and relevant to the planning decision. It will only be in the rarest of circumstances that you might be asked to provide personal information of the type that most of us would prefer to keep private or confidential. Therefore, to avoid the need to edit the digital recordings, what we would ask you to do in the first instance is to try not to add information into the public record that you would wish to keep private or that is confidential. Does anyone have any questions with regards to this matter? No. Can I repeat the requests made in the arrangements conference that in order to minimise background noise, you make sure your phone is switched off or turned to silent, and that you stay muted with your camera turned off unless you are speaking. As this is a virtual meeting, it has to be structured in such a way that questions or points that you may wish to raise can be done so at the relevant point in the proceedings. When we get to those points, I would ask that if you want to speak, you switch your camera on and either use the raise a hand function on MS Teams or ask to speak at the appropriate time. Can I also remind people that the chat function on Teams will not work, so please do not try to use this to ask any questions or to post any comments. If you do not manage to ask your question or raise your point at the relevant point in time, there will be an opportunity at the end of the meeting for you to raise this under item 7 on the agenda, any other matters. Depending on the length of this morning's meeting, we will adjourn for a break at appropriate points in the agenda. For those of you that are participating in the meeting, you will need to switch off your camera and microphone for the duration of the break. For those people watching the live stream, we will have to stop the live stream in order to give us clear recording files. As a result, at the point at which we commence the meeting and restart the live stream, you will need to refresh your browser page to view the restarted stream. I will remind you of these arrangements again should we need to adjourn. Are there therefore any comments or questions on regarding any of the points I've just made? No. You are all here today because you are the applicant or representatives of the applicant. You represent the local authority or a neighbouring authority. You represent bodies that are statutory parties. You have sent a relevant representation and have thus become an interested party. You are an individual or body affected by the application for compulsory acquisition of lands or rights over lands. You have been given other person status or a combination of any of these categories. There may also be people here who are not covered by any of those descriptions. Whichever you are, you're all very welcome. This meeting will follow the agenda as set out in my letter of the 24th of January 2022, which I shall refer to from now on as the Rule 6 letter. I hope you have a copy of this letter to hand. If you do, can you please turn to Annex A, which sets out the agendas for this morning's meeting. And if I could ask Mr. MacArthur to bring it up on the screen, as you will at this point. Lovely. As you will see, we're currently on item 1 of that agenda. The letter and agenda are also available on the project page of the National Infrastructure website, the address of which is at the top of my letter. The Rule 6 letter itself can be found in the examination library at reference PD-005. So let me briefly explain why we are here today. We're here to focus on the way in which we intend to examine this application. We will be discussing only the procedural aspects of this examination today. This meeting is not about giving evidence, and we are not discussing either the merits or any concerns that you may have regarding the application itself. These matters will only be considered once the examination of the application begins, which follows the close of this preliminary meeting, which will be tomorrow, Wednesday, the 23rd of February 2022. Hopefully, by the end of this meeting, you will be comforted that there will be sufficient opportunities throughout the examination for you all to express your views. This is a working meeting. In running it, we intend to run it fairly and efficiently, allowing everyone who wishes to do so to participate. However, we will endeavour to make sure that you and our contributions are as to the point and as focused as possible, so that we make the best use of the time available and allow anyone who wishes to speak an opportunity to do so. I hope that you will support us in this endeavour. Notes are being taken of this meeting, and these will be placed on the project page of the National Infrastructure website and deposited at the locations listed in Annex F of the Rule 6 letter as soon as practicable after the close of the preliminary meeting. As already mentioned, digital recordings are being made of today's meeting, and these too will be placed on the project page of the National Infrastructure website as soon as practicable. With this in mind, it would be enormously beneficial to us if each time you speak, you could state your name and if you are representing someone, who it is you represent. Could you also let us know how you would like to be referred to, i.e. Dr, Mrs, Ms, Mr. Please also bear in mind that the only official records of today's proceedings are the notes and the digital recordings. Tweets, blogs and similar communications arising out of this meeting will not be accepted as evidence in the examination of this application. So thank you. So if we can stop sharing the agenda now, I'm now going to move on to ask people to introduce themselves. The case team has provided me with a list of those interested in other parties who have expressed or wish to be heard today. Those persons are people representing the following organisations. We have representatives from Ørsted, who are the applicants, East Riding of Yorkshire Council, Walkington Parish Council, the Royal Society for the Protection of Birds, the Holderness Fishing Industry Group, the East Riding of Yorkshire and Kingston upon Hull Joint Local Access Forum, National Grid Carbon Limited, BP Exploration Operating Company Limited, and Mr and Mrs Dransfield and their representatives. Can I just check that there is no one I have missed? No? Okay. I'm going to now ask those of you who are participating in today's preliminary meeting to introduce yourselves to the examining authority and the people who are watching the live stream of this event. As I've already mentioned, when I state your organisation's name, if you could unmute yourself, and if you have your camera turned off, switch it on, then introduce yourself, stating your name, and as I've mentioned, how you'd like to be referred to. And if you are representing someone, who it is you represent. So I'm going to start with the East Riding of Yorkshire Council. Do we have a representative from the East Riding of Yorkshire Council?
Morning, Madam. Yes, I'm Jennifer Downs, representing East Riding of Yorkshire Council, and it's Ms Downs.
Lovely, thank you. And then do we have a representative from Walkington Parish Council?
You do, yes. I'm Mr Jamie Appleton of the Walkington Parish Council.
Thank you. And you're Mr Appleton, aren't you?
Yes.
Okay, and then have we got some representatives from the Royal Society for the Protection of Birds?
Hi, my name is Andrew Dodd. I'm from the Royal Society for the Protection of Birds, and it's Mr Dodd, and I'll be the only person from the RSPB speaking today.
Thank you. Do we have any representatives from the Holderness Fishing Industry Group? I knew they were intending to come today, but I don't know if they've arrived. Okay, we'll move on. Do we have the representative from the East Riding of Yorkshire and Kingston upon Hull Joint Local Access Forum?
Yes, it's Dr Andrew Hersom, and I represent the Joint Local Access Forum.
Thank you very much, Dr Hersom. Okay, and then can I have the representative from National Grid Carbon Limited, please?
Good morning, Madam. I'm Gary Sector, a partner at Offshore Goddard LLP, representing National Grid Carbon Limited, and I'm Mr.
Thank you. And then can we have anyone who's representing BP Exploration Operating Company Limited?
Good morning, my name's Maxwell Harrison. I'm representing BP, and it's Mr. Harrison.
Thank you, Mr. Harrison. And then do we have Mr. and Mrs. Dransfield and or their representatives?
Good morning, Madam. It's Richard Cressel here. I'm representing Mr. and Mrs. Dransfield, who are not here, and it's Mr. Cressel.
Thank you. Before I turn to the applicant, can I just check that I've not missed anyone? No. If I can then ask the applicant to introduce themselves and their team, if anyone else from their team is speaking.
Yes, thanks, Madam. My name is Amy Sterling. I'm an associate at Pinsent Masons. and I will be representing Ørsted Hornsea Project 4 Limited, who is the applicant, as you've noted, for the Hornsea 4 offshore wind farm order. Ms Sterling is fine. I'm accompanied today by Mr Jamie Baldwin, who's the Project Development Director at Ørsted for Hornsea 4. And Mr Baldwin is fine. Thanks.
Thank you. Right, can I just confirm that I've now heard from everyone who wishes to participate in today's event? Thank you. So I'm just going to turn to item 2 on the agenda. Whilst the preliminary meeting for this application is taking place virtually, the format, content and procedure will be very similar to traditional face-to-face preliminary meetings that we've held pre-pandemic for previous development consent order examinations. The purpose of this meeting is to establish the procedures and timetable for the examination of the proposed development. In order to minimise video conferencing fatigue, in Annex B of our Rule 6 letter, the EXA has set out in detail the purpose of the preliminary meeting and how it intends to carry out the examination. For expediency, I'm going to assume that everyone has read this, and therefore I do not propose to spend time reading it out now. It is important to the examining authority that you are clear in your understanding of the process. Therefore, if there is anything you are unclear about, or on which you need clarity, then please do ask. Before I ask if there are any questions regarding the examination process, I just want to take the opportunity to advise you of the current approach regarding the holding of events. The public health restrictions, as we all know, regarding the holding of in-person events that were in place because of the COVID-19 pandemic have in the main been lifted. However, going forward, the Planning Inspectorate guidance is that rather than returning to solely in-person events, in order to enable everyone to participate, events should be held either wholly or partially virtually. To clarify, wholly virtual is what we are doing today, where all participants are online. Partially virtual, which is often also referred to as a blended event, is where people can attend either in person at a physical venue or dial into the physical venue and attend virtually. Before I ask if anyone has any questions regarding the examination, if you have any specific points to make regarding the draft timetable, hearings or deadlines, please note that these will be considered under item 5 and 6 on the agenda. Can I therefore ask, with the exception of the format of future events, which I shall deal with separately, on the basis of the information set out in Annex B, are there any questions about the way in which the EXA intends to examine this application? No. So I'm just going to turn to the format of events. I note from the responses received at the procedural deadline that the East Riding of Yorkshire Council, Exam Library reference PDL-004, and Natural England, Exam Library reference PDL-006, have both indicated that they are happy to attend events virtually. Does anyone else have any observations which they wish to make about whether events should be held wholly or partially virtually? If you'd like to.
Yes.
Ms Sterling.
Yes, Amy Sterling on behalf of the applicant. Yes, is the applicant's preference for substantive hearings where various technical matters, largely, for example, issue-specific hearings, to be held in person, or at least with the applicant having the ability to attend in person, albeit the applicant also recognises the benefits of ensuring that people can also participate and attend virtually in those processes. So we sort of favour a blended approach for the substantive hearings.
And can I just ask what benefit that has over why you need to be in the room?
I think we just would find it preferable to allow, when experts are speaking, we feel that the evidence flows really better rather than a disjointed approach amongst our own team.
But bearing in mind that obviously it could still be disjointed, given that people will have to dial in virtually.
If people have to dial in virtually, yes. Our preference would have been in person, although we recognise, particularly with the number of holidays, etc., which are unavoidable almost in the examination timetable, that the blended approach will have to be used. But yeah,
maybe I can just take the opportunity to explain. One of the things that's come out of the COVID-19 pandemic is that the Planning Inspectorate has acknowledged that in order to enable participation of all participants. So, for example, particularly interested parties and third parties who may have jobs that they have to attend during the day, or may have mobility issues, or may have concerns about COVID. We will not have a singly in-person event anymore. We have to have the ability to enable those people to be part of the process in order that it's fair. And so we will always have the opportunity for people to dial into events. So there will never be just an in-person event for this examination anyway, going forward. So I just want to make that very clear. So the opportunity is a blended event or a wholly virtual event.
Yes, thanks for telling you. That's completely understood. Just to reiterate, the applicant's preference is to be able to present its evidence in person, but it's recognised that the blended approach will be taken forward.
Okay, thank you ever so much on that. Does anyone else? I notice that we've got a hand up. So, Mr. Dodge, what would you like to say?
Just to confirm that we're of a similar view to those expressed by East Riding and Natural England, that we would prefer virtual events for the various reasons that you've set out, and that they've set out too. So just another voice in support of virtual events. Thank you.
Okay. Does anyone else want to say anything about the possibility of running events either virtually or partially virtually? I've got no other hands up, so in that case, we'll take those thoughts away and consider those moving forward. And I'm now going to hand over to Mr. Bradley, who will deal with the next item on the agenda.
Good morning. Could we have the list of principal issues up on screen now? So this is now item 3 in the agenda, our initial assessment of principal issues. It might be useful for you to have Annex C of the Rule 6 letter in front of you, but this is a shortened version of the, indeed, the main headings of the principal issues, and the detail is within the Annex C. Now, this list is broadly based on the matters set out in the national policy statements for energy, renewable energy, and for electricity networks infrastructure, but it's not an exclusive list of issues, and some may overlap indeed or interrelate. It provides the framework of issues for the examination going forwards, although it doesn't preclude the EXA from amending the list at a later stage in the process. If any additional issues come to the EXA's attention which appear to be important and relevant, they will also become part of the examination. So we're seeking to establish in this meeting if there are any additional issues which any party would like to raise which might or should affect the structure of the examination. As already indicated, it's not our intention to make any procedural decisions today, but we will listen and consider your comments after the meeting. I'll now invite submissions, and I'll give the applicant a chance to speak at the end of the agenda item. We've had a request from RSPB to speak on this agenda item. Mr. Dodd, would you like to now speak?
Thank you, Mr. Bradley. Yes, we've asked to speak on this item and item 5, and we do see that they're linked insofar as they relate to offshore ornithology matters which fall under the habitat regulations assessment principal issue. The timing and nature of the provision of further information by the applicant during the course of the examination, which falls obviously under item 5, to us interacts with the level of detail that may be relied upon in the draft DCO and the deemed marine licence conditions and any associated outline plans, and whether or not any additional requirements or conditions might be necessary. So in that respect, we very strongly support submissions that have already been made by Natural England in their relevant representation, RR029. And just to kind of hopefully draw this out, we see there's a golden thread really between the level of confidence we have in the impact assessment side of things through any discussions and agreement on the predicted adverse effects into the appropriate nature scale of any compensation, which then leads to the matters under discussion here in terms of the principal issues and the draft DCO and any conditions and requirements that may flow from that. I'm not sure. I'd take your guidance as to when to raise the point we had under matter 5, but I felt I could raise it here because it feels like it links with this item. So, but I'm happy to defer it to item 5 of the agenda if that would help.
I think it will be more helpful in item 5. Let's stick to the principal issues list at the moment.
Okay, that's fine. Thank you.
Good. Thank you very much, Mr. Dodd. I see Mr. Cresswell has his hand up. Mr. Cresswell.
Thank you, and apologies if I'm in the wrong place with this, but I'm not entirely sure where to put it, and I wouldn't want to miss the opportunity. But please do tell me if I'm coming in too early. My client. Sorry, I'm representing Mr. and Mrs. Dransfield. My clients live very close to the onshore substation, and as they've set out in their relevant representation, there are a number of issues that they are concerned about, but there's also a very key procedural issue in relating to the pre-consultation, and indeed the fact that they were excluded from the initial consultation in error, it seems. That does not appear to be one of the principal issues, but I noticed that various others of the interested parties have also raised queries in relation to consultation, and therefore I just wanted to check to see whether or not that should be a principal issue, or indeed how that was going to be dealt with. And again, I apologise if I've raised it too early in the meeting.
Thank you. We won't consider this obviously as evidence at this meeting, but it's certainly of relevance to raise in future. We will take away your point and consider it carefully.
Many thanks.
Thank you, Mr. Cresswell. Now, are there any other people present who wish to raise anything on principal issues? I'm looking for hands up. No, I don't see anything else. So in that case, Mr. Baldwin or Ms. Sterling, for the applicant, would the applicant wish to add anything?
Thanks, Amy Sterling on behalf of the applicant. No, nothing further to add other than that, of course, we'll be responding to the relevant representations at deadline 1, including concerns over pre-application consultation and the relevant representation made by Mr. Cresswell on behalf of his clients. And happy to discuss anything in more detail at later dates after that.
Thank you, Ms. Sterling. Thank you. I'll now hand over to Ms. Dowling, who will deal with agenda item 4, which are procedural decisions taken by the XA.
Thank you. I'd now like you to ask that you turn to Annex E of the Rule 6 letter, where you will note the examining authority has made a number of procedural decisions. Annex E provides full detail behind these requests, and I therefore do not propose to repeat them now. Since the Rule 6 letter was submitted, there have been a number of further additional submissions that the examining authority has accepted into the application, and this includes a letter of representation from Hull City Council, which is reference AS-001 in the examination library, a written submission from the Holderness Fishing Industry Group, reference AS-025, and a written submission from the National Federation of Fishermen's Organisations, reference AS-026. In addition, the examining authority has accepted a number of documents from the applicant, which was submitted in response to Section 51 advice issued by the Planning Inspectorate on the 26th of October 2021. That is reference PD-003. These responses can be found in the examination library under references AS-002 through to AS-024. Any responses to these submissions should be submitted at deadline 1, but in the interim, does anyone have any procedural questions regarding the acceptance of any of these submissions? No. In addition, at the procedural deadline on the 11th of February, the examining authority received correspondence from the applicant, BP Exploration Operating Company Limited as the operator of the Northern Endurance Partnership Carbon Dioxide Transportation and Storage Project, solicitors on behalf of NEO Energy and SNS Limited, East Riding of Yorkshire Council, the Marine Management Organisation, Natural England and the RSPB. This correspondence can be found in the examination library at references PDL-001 through to PDL-007. The matters raised in this correspondence with regards to the examination timetable and deadlines will be dealt with when we reach that item on the agenda. But I'm going to deal first with some of the correspondence from the applicant, which was submitted at PDL-001. In addition to the points it raised regarding the timetable and deadlines, the applicant raised a further 2 points that it wished to raise at this meeting, which I will deal with now. And that was regarding a schedule of changes and a statement of common ground, in particular, whether one was required with the National Farmers Union. For the benefit of everyone at this meeting, can I just ask Ms Sterling on behalf of the applicant to very briefly outline what they are requesting with regards to using a schedule of changes?
Yes, Amy Sterling on behalf of the applicant. Thank you. Yes, as you and the examining authority and others who have reviewed the Planning Inspectorate project webpage will have noted that in the response to section 51 advice, the applicant took the approach of providing schedules of change to application documents that had previously been submitted. The applicant is proposing to take a similar approach throughout the examination, and effectively what the schedule of change does is note the changes proposed, for example, via tracked change of particular paragraphs to an application document which has been submitted. And it's proposed that the schedule of change for each document will be a rolling schedule of change, so you'll be able to see which changes are being proposed at that particular deadline, plus all changes that have gone before. But that will avoid having to resubmit the application document and clean and track change at each deadline should updates be required. However, the applicant would of course be willing to update the main document to ensure that all the changes are compiled into the one document at any point during examination on request of the examining authority, and certainly before the end of examination.
Can I just, before I ask if anyone else wants to respond on the matter, can I just ask a couple of questions myself?
Yes.
The first one is, can you just advise how that would make the documents accessible to all people who want to participate in the examination, given the complexity of some of the documents and the amount of changes that may be required to them as a result of the examination process? I.e., how easy is it to use the schedule of changes alongside an electronic document, given all of these documents are electronic?
Yes, Amy Sterling on behalf of the applicant. The way that the schedule of change would work for any given document would be that at most a person reviewing the documentation would only have to look at 2 documents, so the original document and the most recent version of that schedule of change, which would narrate all of the changes. We actually think that that's probably more accessible than having to try and track through various versions of documents which may be uploaded throughout the examination process, including clean versions and track change versions. So we're actually trying to, the aim is to be more accessible, although of course we welcome comments on that approach. It is noted that should the schedules of change become unwieldy, for example, that we're more than happy to update the document, as I said, at request of the examining authority, or if indeed any stakeholder indicates that they are finding the process difficult, we're of course happy to review it. Our aim is to streamline the documentation rather than cause further confusion. So yes, welcome any observations on the approach.
And can I just clarify, I think I noted from a procedural decision, but the assumption is that at the end of the examination you would produce a clean set of documents, up-to-date set of documents?
Yes, that's correct.
Okay, thank you. Can I just ask at this point if anyone wants to respond on this suggestion by the applicant that they use schedule of change rather than updated documents throughout the examination? No one wants to respond. In that case, thank you for providing the additional explanation. Following this meeting, the examining authority will consider the matter further and advise you of its decision in the Rule 8 letter that will be issued as soon as possible after this meeting. Before talking about statements of common ground in general, I can confirm, having considered the matter further, that the examining authority is of the opinion that a statement of common ground with the National Farmers Union would not be necessary, and this will be formally confirmed in the Rule 8 letter. If I can now ask Ms Sterling on behalf of the applicant to outline what it was that the applicant wanted to raise on this matter, and in doing so, could I also ask that she respond to the request made by the solicitors on behalf of NEO Energy brackets SNS Limited for a statement of common ground with all the offshore oil and gas operators? Thank you.
Yes, Amy Sterling on behalf of the applicant. Thanks, Madam, for confirming that a statement of common ground was no longer being sought with the National Farmers Union. That has resolved the submissions we wanted to make on that point, which was that we weren't progressing a statement of common ground at this time because we felt that all concerns that raised at pre-application consultation had been adequately addressed, and we noted that no relevant representation had been made. So we considered that one now to be closed, which is useful. In relation to the submission made by on behalf of NEO, a position statement with a joint position statement between the applicant and NEO has been provided to NEO, and comments are awaited, and it is intended that that will be submitted at deadline 2 of the examination. In relation to the other parties referenced in NEO's letter, being Bridge Petroleum, Harbour Energy and Perenco, of course they didn't make a similar request, and the applicant is in commercial negotiations with these parties and will be providing an update on those negotiations in the response to relevant representations at deadline 1. At present, it's not anticipated that a similar joint position statement will be required with those parties, but if it is required, we will aim to provide those at deadline 2.
Okay, and can I just ask you to clarify, for the benefit of people who are new to the process, what the difference between a joint position statement and a statement of common ground is, please?
Yes, Amy Sterling on behalf of the applicant. They're broadly similar. The joint position statement tends to not narrate, because it's more appropriate for commercial negotiations where the detail of the commercial interests between the parties can't be rehearsed as in statements of common ground, setting out sort of details of matters agreed and not agreed, but it gives a flavour, as it were, of the status of negotiations between the parties and the key issues which are under negotiations, without necessarily disclosing each party's commercial position.
Thank you. I don't think we have anyone here from NEO who wants to respond, but does anyone want to respond on that matter? Does anyone want to raise any points with regards to statements of common ground in general? I'm assuming from the silence that's a no. So,
just to confirm, sorry, Amy Sterling on behalf of the applicant, we do have a few other comments on statements of common ground, but I'm not sure if we will be discussing that under other items. I think one particular one we noted in our response to Rule 6 was the statement of common ground sought in relation to endurance. I'm not sure if you'd like to hear my submissions on that now, or
we might as well. I think it's an appropriate point in the agenda. So, do you want to?
Yes, great. It was just really to make the examining authority aware. We appreciate when the Rule 6 was issued that the relevant representation by BP hadn't yet been submitted. Just to confirm that the applicant is progressing a joint position statement with BP, who, as you've already noted, is the appointed operator on behalf of the licence holder of the carbon storage licence, being Equinor, Carbon Sentinel, who are essentially National Grid Carbon, and BP. As the appointed operator, the applicant feels that it is most appropriate to progress the position statement with BP. The aim is, that will be being submitted at deadline 1 of the examination. And on that basis, the applicant isn't progressing a position statement at the moment with the other parties, particularly Drax and Shell, who are not part of NEP, but as far as we understand it, potential customers of the NEP project. So yes, it was just to make the examining authority aware that the position statement with BP as operator will be submitted at deadline 1, and that is the only one which will be submitted then.
Okay, given we've got representatives from both National Grid and BP here today, I'm going to ask them to respond in a second, but can I just come back to you on point? You said it wasn't being progressed with Drax, and what was the other party? Because they were the partner.
We know Shell had already also made a relevant representation.
Okay, thank you. So if I can ask if anyone from either BP or National Grid want to respond on what they've just heard with regards to that position statement. Andrew Dodd.
Sorry, I'm representing the RSPB, so I'll wait for anyone else to from BP or National Grid to respond.
Thank you.
This is Mr. Harrison from BP.
Okay, Mr. Harrison.
Yes, so we did submit a late relevant representation, and apologies, I'm new to the whole development consent order process. And we were informed that it would be taken into account at the first deadline in March, but we wouldn't be granted kind of interested party status at this moment. I can confirm that legal teams between the applicant and BP are in conversation about this position statement or statement of common ground. I apologise, I don't know which one it is, but I can go back and find out the answer and discuss this with our team. But I believe that that is the intention. I just need to go and confirm it with the legal team.
Okay. If you could get back to us as soon as possible on that, that would be great, and no later than deadline 1.
Yes.
So does anyone from National Grid want to say anything at this point?
Madam, it's Gary Sector on behalf of National Grid Carbon Limited. And just to say, Madam, our interest is specifically in relation to the terrestrial carbon capture underground storage network. So we wouldn't be anticipating being involved in anything around a Northern Endurance Partnership.
Okay, thank you. Okay, if we can come to the very patient Mr. Dodd on behalf of the RSPB.
Thank you, Mrs. Dowling. So I just wanted to note, and I note from the preliminary timetable that the deadline for the initial statement of common ground is set at the 8th of March, and just to note for the record that we have not yet been approached by the applicant to on an initial statement of common ground. I will fully understand that they will have a huge amount of work on their plates, but I just wanted to note for the record that that deadline is now looking unlikely from our perspective anyway.
Okay.
Yeah, but obviously we recognise the statement of common ground process and fully understand it, so we'll work with the applicant throughout the examination.
Yes, it is very much an iterative process, but at the end of the day, the sooner that those can be resolved, the better. So if I can just ask Ms. Sterling if there's anything she wants to come back on at this point from what she's heard from the representatives of NEO, BP and the RSPB.
Thanks, yes, Amy Sterling on behalf of the applicant. Just to confirm, yes, the draft statement of common ground with the RSPB, I understand from my client, will be sent today.
Okay, thank you. So is there anything else with regards to statements of common ground that anyone wants to raise at this point in time? No. So again, as I've mentioned before, the examining authority will discuss this matter further following this meeting and advise you of our decisions on what has been discussed and suggested in the Rule 8 letter. In relation to the point raised by the East Riding of Yorkshire Council in its submission PDL-004 regarding the issues surrounding the submission of their local impact report, the examining authority is satisfied with the approach that's being proposed, and this will be confirmed in the Rule 8 letter. Can I just confirm at this stage if there's anything further that the Council wishes to raise on this matter? Ms Downs.
Jennifer Downs, Registrating of Yorkshire Council. No, nothing further to raise at this time.
Thank you. The matters raised by Natural England in PDL-006 and the Royal Society for the Protection of Birds in PDL-007 will be considered under the next item on the agenda with regards to timetabling. and deadlines. So having discussed the specific procedural issues raised in submission made at the procedural deadlines, is there anything else other than matters relating to the timetable deadline that anyone wants to raise at this point in the meeting? No. So can I just remind you that interested parties are asked to submit any written comments that they may wish to make on any of the additional submissions or the documents submitted at the procedural deadline by deadline 1. I'm now going to hand over to Mr. Marn, who will talk about the draft timetable for the examination, hearings and site inspections.
Thank you, Ms. Dowling. I am going to deal with items 5 and 6 on today's agenda together. I'm going to look at the draft examination timetable, which is as Annex D to the Examining Authority's Rule 6 letter, and then I'll move on to the proposed dates and formats for the hearings and site inspections. You might find it helpful to have Annex D of our Rule 6 letter in front of you if you have it, and I'm going to ask Mr. MacArthur to share the draft timetable on the screen, please. Thank you. Hopefully you can all see that now. Again, this is a condensed version. The full version is in the Rule 6 letter. As you've all seen the draft timetable, and in the interest of brevity, I don't intend to go through all of it in full. However, I am going to pull out some of the key points before inviting comments from you. I'll deal with the proposed examination timetable first, then site inspections, and then hearings. So firstly, the proposed examination timetable. The timetable in front of us here is provisional. Having heard your comments today, the Examining Authority will consider any proposed changes and, as soon as practicable after this meeting, issue a Rule 8 letter to finalise the timetable. You'll see provision in the draft timetable for the Examining Authority to issue written questions. The intention is for the first written questions to be issued alongside the Rule 8 letter, though they may follow shortly afterwards depending on circumstances. If the Examining Authority considers it necessary, more than one round of written questions may be issued. Most of you will be aware this is quite usual for a case of this size and complexity, and a further round of written questions is provisionally pencilled in for the 30th of May. The Examining Authority can also issue specific requests for information from named parties at any point during the examination if this is considered necessary. This would be done through the issue of a Rule 17 letter. As you can see, the examination is structured around a series of timetable deadlines. Being a primarily written process, these are the dates by which most of the critical information will need to be submitted. The submissions will be collated on the next working day and subsequently published. The Examining Authority considers it essential that deadlines are met to facilitate a fair and efficient examination. Deadline 1 is currently timetabled for the 8th of March. This is when the Examining Authority will be expecting to receive written notifications from parties who wish to speak at one of the subsequent hearings or would like to attend an accompanied site inspection should one be held. Could any parties intending to submit a request to attend any of these events, please read the information in the Examining Authority's Rule 6 letter and its annexes very carefully to ensure that you understand the reasons and procedures around each and to make sure your representation is directed along the most appropriate channel. Deadline 1 is also the deadline for local impact reports from the relevant local authorities, comments on the published relevant representations, and initial statements of common ground, amongst others. Moving on, deadline 2 is provisionally programmed for the 29th of March. This is when interested parties would need to submit their full written representations. At this deadline, the Examining Authority also expects responses to its first written questions and any comments on the local impact reports. As you will see, the draft timetable includes a further 6 deadlines when the Examining Authority requires the submission of specified information. For expediency, I do not intend to go through these in detail now, but if you intend to be involved in the examination, please do familiarise yourself with them. For the avoidance of doubt, the examination timetable specifies that the precise deadline for submission of information is at 23:59 on each of the specified dates. The time is common to all parties, so ensures fairness. It also reflects the circumstances for parties who are working or otherwise occupied in the daytime and who rely on evenings to work on their representations. Now, in relation to that, we have noted a request in the applicant's procedural deadline submission, dated the 10th of February, that this be changed to 6 p.m. in the evening. Sterling, does your team wish to make any further comments on this at this stage beyond those in your letter?
Amy Sterling on behalf of the applicant. No, just to confirm, the rationale for a requested change was Ørsted's commitment to the health and well-being of its employees, which it felt would be best served by a 6 p.m. deadline, albeit your comments in relation to other parties who may have irregular working hours are noted.
Thank you. Does anybody else in the meeting have a comment about this deadline time at this stage? I haven't heard anything. I don't see any hands, so I'll take it as no. OK, thank you, Ms. Sterling. We'll take the representation away and we will confirm our final position that in our Rule 8 letter. The applicant's procedural deadline submission also draws the examining authority's attention to the proximity of some of the proposed deadlines and events to public holidays, including Easter. Natural England's not with us today, but we have seen a concern raised in its procedural deadline letter, dated the 9th of February, around its resourcing of attendance at any hearings held during the week commencing 25th of April. So in relation to Easter and holidays, again, Ms. Sterling, does your team wish to add anything further to your letter at this stage?
Amy Sterling on behalf of the applicant. Just to reiterate what we said in the letter, we are willing and able to meet the timetable as drafted. We note that Easter is a particularly constrained time. There are several either school or public holidays in April, May and also this year now in June. We're keen to maintain the examination timetable insofar as possible and for the efficient running of the 6-month period. We note, as is also noted, I believe, in Natural England's response, that the ability for participants to attend virtually may go quite some way to mitigate the difficulties which public and school holidays may cause for hearings. But nevertheless, we felt it was worth bringing to the examining authority's attention in case anyone else didn't. Thank you.
Thank you, that's all noted. As you're aware, I think everybody should be aware, we're constrained by the legislation here to a maximum of 6 months for the examination, so we actually have very little wriggle room available to move things around. But looking at that point on the timetable and Natural England's resourcing issues, if it's possible, the examining authority will go away and look at the schedule for any issue-specific hearings that are likely to involve Natural England for later in the week, commencing the 25th of April, sorry. So let's say maybe we can schedule the ones that might involve Natural England for Wednesday, Thursday or Friday, which may help a little. Or if it is possible, we will look to carry over 1 or 2 to the following week. And again, as Ms. Sterling's just mentioned, there's an additional bank holiday in that one too. So we try to do that slightly later in the week, potentially Wednesday or Thursday. We'll take those thoughts away and we will see if we can make any revisions, and we'll give a decision again in that to our final timetable in the Rule 8 letter. Did anybody else wish to make any points on that? I'm going to come back to the RSPB specific request in a moment, but does anybody else have a comment on the deadline dates? I haven't heard anything, so I shall move on. So Mr. Dodd, the RSPB's procedural deadline submission of the 14th of February raises a couple of matters in relation to agenda item 5. You've requested clarification from the applicant in respect of offshore ornithology and what further documents will be submitted to the examination and at what deadlines. Now, I think we appreciate the reason for the request, but I do think the detail of this needs to be left until we have started the examination. Do you have anything further to add other than what was in your letter in relation to that?
Not in detail. I mean, just to respond to your observation, that will cause us problems in terms of timetabling our staff resource. I mean, where the complexity of this particular application in respect of offshore ornithology matters means we're, as an organisation, this may be true of Natural England, but I'll speak just for the RSPB, means we are consulting many more colleagues than we would normally otherwise do, and drawing them in to discuss specialist matters. And therefore, the sooner we can get, it's really all we're asking for from the applicant is an indicative dead timetable as to when they expect to submit further documentation, which from offline discussions with them, we are expecting there to be further information at some point, but we don't know the timings of that, and therefore we can't schedule our resources. So it's really just seeking clarification to help us engage with the examination as effectively as possible. So the sooner, as soon as possible, and I've been interested to see kind of hear what the applicant's response is and kind of what their plans are. They may not be able to say in detail now, but it was just a request to help us help them and the examination.
Thank you, Mr. Dodd. As I say, we do appreciate the reasons behind your request. I think we are teetering on the brink between examination matters and procedural matters here. But Ms. Sterling, did you wish to make any comments further on that today?
Yes, Amy Sterling on behalf of the applicant. Hopefully, just to reassure Mr. Dodd that we will be providing a list of the offshore ornithology related submissions that at this point we anticipate making into examination at deadline 1, along with related deadlines for those submissions, and hopefully also to reassure Mr. Dodd that the deadline for those submissions is either deadline 1 or deadline 2 as currently programmed, so they will be made available early in the examination process.
Thank you, Mr. Sterling. That's very useful. I hope that reassures you, Mr. Dodd, and gives you some indicators.
Yes, just like to thank Ms. Sterling and yourself for that clarification. That's very helpful. Thank you.
Does anybody else wish to comment on this matter? Again, bearing in mind we're dealing with the examination procedure here rather than its merits. No, I don't hear anything there, so thank you very much for all of that. Coming back to you, Mr. Dodd, you've raised the second point in your procedural deadline submission in relation to the timing of the proposed issue-specific hearing on the draft DCO. We have seen your point. And we'd note that the week commencing the 18th of July is reserved in the draft timetable for further hearings if required. And this could include a further compulsory acquisition hearing if necessary. We also note that the timetable as drafted includes a request to the applicant to produce updated versions of the draft DCO at each major deadline. Anything you wish to add, Mr. Sterling? Mr. Sterling. Sorry.
Yeah, sorry, Amy Sterling on behalf of the applicant. We actually, yes, we did have a point in relation to the draft DCO, just to make the examining authority aware that we're actually intending to provide the first update in response to relevant representations at deadline 1 on the 1st of March. That's really a reflection of the number of suggestions that were made by Natural England and the MMO and their relevant representations relating to DCO drafting, many of which have been taken on board. So we felt it was prudent to deal with all of those at once and submit the updated draft at deadline 1.
Thank you, that's useful. Is there anything you wish to add, Mr. Dodd?
Not at this stage. That's very helpful clarification on the updated DCO, and obviously I think our comment was just in terms of the opportunity to respond to any recommendations that the examining authority's commentary on the DCO, and whether there'd be an opportunity after the 28th of July date for that to be put into the examination for any last kind of almost last minute hearing if there are matters still to be discussed. But obviously that you obviously that's within your discretion. So
yes, certainly we take that point away, but you will have ample opportunity, I believe, at the deadlines to send in any written representations on that you wish to make towards the last two deadlines.
Thank you.
Does anybody else wish to comment specifically on the draft DCO issue specific hearing? Or indeed, before I move on then to site inspections and hearings, does anybody else wish to comment on the timetable? Any other comments at all on the timetable? I don't see any hands. I don't hear anything, so I am going to move on. So Secondly, I'm moving on to agenda item 6, and firstly, the site inspections. The examining authority carried out a series of unaccompanied site inspections from public land on the 9th and the 10th of February. During these inspections, the examining authority was able to view the majority of the proposed onshore and coastal locations for construction works and the proposed development, and the wider landscape, environmental and social contexts. Notes and route maps of the inspections were published on the 15th of February and can be viewed on the project page of the National Infrastructure website, so I do not propose to go into them in any detail now. For reference, the examination library numbers are EV001 and EV002. It is possible that further unaccompanied site inspections may be undertaken during the course of the examination. Now, given the extent of coverage that the unaccompanied site inspections gave the examining authority, it is considered unlikely that it would be necessary to visit those sites or areas again. Therefore, an accompanied site inspection would only be necessary to view any remaining land where there is no public right of access or where there is no clear view from public viewpoints. The draft examination timetable includes a deadline for suggested prospective locations for any accompanied site inspection, and this is the 8th of March. If anybody wishes to make any such suggestions, they must be received in writing by that deadline. Please can I ask that you study the unaccompanied site inspection maps and notes before writing in to avoid suggesting any repeat visits. In your submission, please also provide a detailed explanation of why you consider an accompanied inspection to that location is required, including what could be viewed there, why it is important, and what would need to be done to arrange access. If required, an accompanied site inspection has been timetabled for the week commencing 18th of July. Any request to attend any such site inspection must be received by deadline 1, which is the 8th of March. Does anybody have any questions or comments in relation to site inspections before I move on to the hearings? Nothing heard there, so I'm going to move on finally to this part of the agenda. I'm going to move on to deal with hearings. Looking at the proposed timetable, you'll see that the examining authority is proposing to hold an open floor hearing in the evening of Monday, the 11th of April 2022. An open floor hearing is generally the best opportunity for individuals, community representatives and local interest groups to put their views verbally to the examining authority. This hearing will be held virtually online on Microsoft Teams. The provisional deadline for requests to be heard at this or any future open floor hearing is the 8th of March 2022. Please do read all of the introductory information about hearings and virtual events set out in the examining authority's Rule 6 letter of the 24th of January, including its annexes. If you have any questions or require any assistance with the technology used for this virtual meeting, the case team will be able to help you, and their contact details are on the project webpage. Other hearings may be requested by interested parties or they may be deemed necessary by the examining authority. You'll see that the draft timetable includes an issue-specific hearing on the draft development consent order on the 12th of April and a compulsory acquisition hearing on the 13th of April. Again, these will be virtual meetings. In addition, the week commencing the 25th of April is reserved for a set of further issue-specific hearings. We've already discussed the possibility of focusing these at the end of the week and potentially carrying one or more days forward to the following week. The examining authority's current intention is to announce the topics and formats and to confirm the dates for these issue-specific hearings in the second week, if they're to be held in the Rule 8 letter. If interested parties wish to be heard at any of these hearings, they must notify the examining authority in writing by deadline 1, which again is the 8th of March 2022. The week commencing the 18th of July is reserved in the examination timetable for additional hearings, if it becomes apparent to the examining authority that they are necessary. Topics and formats will be announced by the examining authority in good time ahead of the dates and an opportunity to register would be offered. The examining authority is aiming to issue agendas for all of the hearings at least 5 days in advance. We've already dealt with the procedural deadline comments from the applicant and others in relation to the timetabling of some of these hearings, but are there any other points about the proposed hearings that those present wish to raise? I haven't seen any hands, heard nothing there, so I'm going to move on. Finally, I want to take the opportunity to reiterate the importance of ensuring that information is submitted in accordance with the set deadlines. Whilst the examining authority has the discretion to accept late submissions into the examination, it is only likely to do so in exceptional circumstances. Late submissions can jeopardise the examination timetable and could restrict the ability of other parties involved in the examination to respond to the information. So it is very important for you to note that if you do submit something late, there is always the possibility that it may not be accepted into the examination. So that completes items 5 and 6 on the agenda. Thank you all for your comments and participation. The examining authority will be considering your requests and suggestions as the timetable is finalised for the Rule 8 letter. And I will now hand back to Ms Dowling for item 7, any other matters.
Thank you, Mr Mann. So moving on to item 7 on the agenda, are there any other relevant items that anyone wishes to raise at this point in the meeting? No? Well, that leads me on to item 8, which is the close of the preliminary meeting. I'd like to thank you all for contributing so fully and usefully this morning. The EXA very much looks forward to commencing the examination of this application. May I remind you that both notes and a digital recording of the proceedings today will be made available as soon as practicable on the project page of the National Infrastructure website. Likewise, we will aim to issue our Rule 8 letter with a confirmed examination timetable and first set of written questions as soon as possible after the close of this meeting. The time is now 11:07. And I'd like to thank you all for your participation this morning and announce that this preliminary meeting for the Hornsea project for offshore wind farm is now closed.